Yes, Mr. Chairman. Senate Bill 268 in other states has been referred to as a HALO law, and all this does is create space between first responders and citizens who wish to observe the actions of the first responders, whether it be a EMT working on someone after a car crash or a law enforcement officer making a lawful arrest. What it does is it creates a distance of 25 feet that the individual should stay back from the scene after being instructed by the first responder. And if the individual refuses to stay back 25 feet with the intent to, if you'll see on lines 23, impede or interfere with the first responder's ability to perform such duty, threaten the first responder with physical harm, or harass the first responder. What this does not do is it does not prevent any citizen from standing back and videoing. It doesn't prevent them from standing back and calling law enforcement officers, pigs and fuzz and anything else they want to call them. All it does is keep them back 21 feet. Scientific evidence that has been researched for years and years based on kinetics and physics show that the average person can assault another person within 21 feet, the reactionary zone, or 21 feet, reactionary zone, and this just pushes that back 4 feet. And I'm welcome to answer any questions, Mr. Chair.
Any questions from the committee for the author? There's no one that's signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Chairman Cowser. Is there a second? Second from Leader Hatchett. All those in favor of the motion, please raise your hand. It is unanimous. All right, while you're there, go ahead and do SB 298. We are working off of LC 481544.
Yes, Mr. Chairman. 298 is a result of some legislation that passed back in 2016 and created somewhat of a issue related to local government. Right now, when a city, county, state agency, or public employee is sued, they can assert an immunity defense. But under current Georgia law, if a trial court denies their claim of immunity, they have no immediate recourse. The case must be fully adjudicated before they can appeal. So even if an appellate court later finds they had immunity all along, they've already spent years or long periods of time and significant taxpayer dollars defending a case and that never should have moved forward. So what this gives them right now, this bill restores a process that was in place before 2016 when denials of immunity were immediately appealable under the collateral order doctrine. That changed when the Georgia Supreme Court ruling in Rivera versus Washington, which determined that the General Assembly, not the courts, must decide which rulings can be immediately appealed, which in this case, if the city, say, should appeal or should claim sovereign immunity, and the court says no, they have an opportunity to immediately appeal that. But I know someone wants to offer up and in here, there also is they have 30 days to do that so that the case doesn't languish. But also, I know if we've discussed with GTLA, GMA, ACCG, that the city, in this case, using the city as an example, would have one bite at the apple. They couldn't continue the process on, hoping just to make the case lay there and work toward something like settlements or other things that they would actually have to stay heavy in the process. We have, I would say that with all parties involved, we've had great conversations. I think there may be a couple of tiny threads that we may need to put together, but we're still heavily involved in conversations as this bill moves forward.
And you handed me a copy of proposed amendment, but you're asking the committee to adopt that.
If a member of the committee feels so led, I would greatly appreciate that. Yes, Mr. Chair.
All right, we'll review that after we get to the point of a motion. We have any questions from the committee for the author first? We have two individuals, Larry Ramsey and Rusi Patel from ACCG and GMA, that are for the bill. I'm assuming you're also okay with the amendment. Okay. I don't feel